Good morning.
Please, Lord.
Yes.
Lord, I'd like to mention hearing item 15. Item 16, hearing.
A new one.
I'm for the appellant. And I have received a paper book only yesterday.
This is a POCSO matter.
My lord.
Informant is appearing. Has notice been issued or not?
Informant, no, I don't.
So in a POCSO matter, notice has to go to the informant
Correct.
in terms of the latest
Correct.
decision of the division bench of the
Correct.
Gauhati
Correct.
High Court. So has that been done or not?
Not done.
Then you wait. Let me have a look at it. Yes, text. Yes, Mr. Sharma?
Mention, Lordship.
Yes.
Item number 8
Where?
is a contempt matter. The compliance has already been done. So we want to close this matter. Lordship.
Then you wait for the turn. You want to go back. Just wait. It will reach. It's item number 8.
Yes, Lordship.
Because I'll have to see the file before I close the
Yes,
contempt.
Lordship. Yes, Lordship.
Yes.
Please, Your Lordship. My Lord, may kindly allow me to make a mention of the item number 7. My Lord, here I've taken the consent of the other party also.
All right.
Lordship, since the other matter, whether it can be
For
Yeah.
Mr.
Joshua, Your
Joshua.
Lordship.
As prayed for by Mr. Joshua Shaky, learned counsel for the petitioner, applicant, right?
My Lord.
Learned
Yes, Your
counsel
Lordship.
for the applicant with consent from the other side, list this matter
My Lord, may kindly list it after 4 weeks, my
after
Lord.
3 weeks on a date to be
My
fixed
lord.
by the registry.
My lord,
Make
Your
it
Lordship.
4 weeks.
My Lord.
Yes.
Please, Lordship. Lordship, I beg to mention item number 5.
Item number 5.
Yes,
Yes.
I'm the state respondent.
Yes.
So, Lordship, I'm yet to receive an instruction.
It's an arbitration matter.
Arbitration matter, Lordship.
Arbitration is between private party and state.
Yes.
And it's,
I'm appearing for the petitioner,
yes, is this the 34 application?
my lord.
How
My lord, this matter has been listed time and again. The state government has been, with due respect to the learned counsel.
Mr. Counsel, how a 34 application is maintainable in the High Court? Is 34 not the power of the district court? Because this court doesn't have ordinary jurisdiction.
My lord, I'll come to that, but my lord, first
Anyway,
of all,
I shall take it up when the matter reaches. You wait.
Lordship.
Yes.
Please, my lord. Lordship, item number 27, last item. Lordship.
What do you want in 27?
Lordship, I have a difficulty today. If it may be listed after 2 weeks, Lordship.
As prayed for by Mr.
K. Angami, Lordship.
K.
K. Angami.
Angami Learned Government Council.
Yes, State Council, Lordship.
You're for the other side. No
Yes,
objection.
CP, Lordship.
No objection.
With consent from the other side, list this matter after 2 weeks on a date to be fixed by the registry.
Pleasure, Lordship.
Yes.
Lordship, item number 15, Lordship. on behalf of,
It's a part heard matter. Please wait.
Lordship, I'm mentioning on behalf of,
I am not accommodating. Item 15 is a
Lordship.
part heard matter. You wait for your turn.
Lordship, the thing is,
I think I've made myself clear. So please wait for your turn.
no, Lordship, if I may be allowed to submit, Lordship, Ms. Mary is handling the case. One of her close relatives has expired today. So if,
Yes, next matter.
My pleasure, Lordship. Lordship, I beg to mention hearing item number 22 on behalf of
Just
my.
one sec. Mr. Counsel, there are other PPs, so you ensure that somebody is there. Yes,
Lordship, I beg to mention item number 22 on behalf of my senior Sentiango, Your Lordship. Lordship, my senior has some personal difficulty today.
you're
So,
petitioner.
yes, Your Lordship. Can we list this
All
matter
right,
on
as
Thursday?
by Mr.
Noklai M. Konyak.
Courtmaster, please give the name to my channel. As prayed for by so-and-so learned counsel for the petitioner with consent from the other side, list this matter after 2 weeks on a date to be fixed by the registry.
Deeply of pleasure.
May please, Your Lordship. Lordship, I beg to mention item number 21, Your Lordship, on behalf of the counsel for respondent number 5, YP Gupta.
We are for the petitioner.
Yes, Your Lordship.
Any objection?
No, no objections, Your
As
Lordship.
prayed for by Mr. Your name?
Medovir, Your Lordship, on behalf of YP Gupta.
Meadow Vero, learned counsel for respondent number 5 with consent from the other side, list this matter after 2 weeks on a date to
Your
be fixed
Lordship,
by
if
the
the
registry.
matter may be fixed.
Next,
Obliged, Mona.
what is the point of fixing matters when you are going to take time?
May I please, Your Lordship?
Yes,
I beg to mention item number 23 on behalf of the council for respondent number 6
as prayed for by MS
and solo.
and solo learned counsel for respondent number 6 with consent from the other side,
Lord.
list this matter after 3 weeks on a date to be fixed by the registry.
Much obliged.
item number 1.
There is only, you are alone today?
Yes, ma'am.
Why?
I'm just saying this.
No, but there should be someone to help you to give the files. Please ask for. This is for impleadment.
Yes, Lordship. During the pendency, some of the officials have been transferred. So I'm praying for impleadment of 3 respondents.
So these are the new incumbents.
Yes, Lordship.
Anyone appearing for the other side? Nobody is appearing for the respondents. All right. I'll dispose this of item number 1. Ashwin. Heard Mr. Takamasa,
Arun Long, Your Lordship.
Huh?
Arun Long, Your Lordship.
Courtmaster, name. Heard Mr. So-and-so, learned counsel for the applicant, stop. By way of this application, comma, the applicant is seeking impleadment of Shri Jasakoeli Chusi, Commissioner and Secretary to the Government of Nagaland, Department of Land Revenue, ERP IMNA O. This is the second one. 2 people, no?
3 people.
3 people. You do Roman 1, okay, first one. Now Roman 2, ERP IMNA O, Chief NPWD Nagaland Kohima, and Roman 3, MZ Akho, the Chief Engineer, National Highway, Nagaland Kohima, as respondent numbers 10, 11, and 12 in civil original petition within bracket contempt number 24 of 2023. Done. It appears that during the pendency of the aforesaid contempt petition, comma, Shri Robert Longchari NCS, the Secretary to the Government of Nagaland, Department of Land Revenue, Nagaland, Kohima, respondent number 3 has been transferred out, and in his place, Shri Jasakoli Chusi, Commissioner and Secretary to the Government of Nagaland, Department of Land Revenue, has been posted. Similarly, further, respondent number 5, ER Pukronizu Kera, the Engineer-in-Chief, NPWD Nagaland Kohima, has retired from service and is replaced by ERP IMNA Au. Furthermore, respondent number 6, ERI Tiamrin, the chief engineer, National Highways, Nagaland, Kohima, has also in the meantime retired from service and he is replaced by ERMZ Okho. Stop. In view of the efforts at development, the new incumbents are required to be impleaded in the present contempt petition. And accordingly, the present contempt petition. Stop. It appears that the presence of the aforesaid new incumbents are necessary for effective disposal of the contempt case. Stop. Accordingly, the impleadment sought stands allowed. As such, it is directed so-and-so impleaded as so-and-so. Okay. You will, the details are at paragraph 3 and then prayer. From the prayer, you say so-and-so are impleaded as respondent numbers 10, 11, and 12 respectively in civil original petition contempt number 24 of 2023. Stop. Prayer allowed. Applicant to submit amended cause list to the registry for doing the needful. And in the contempt petition, you say in view of the order passed in IAC 176 of 2024, comma, let notice be issued to the newly impleaded respondent numbers
10, 11, and 12.
10, 11, and 12. Registered post steps by registered post AD within a period of 3 days from today. List after
Lordship,
3
it may
weeks.
be
Order
1
date
week.
to be fixed by the registry. 3 days, you make it 1 week.
Much obliged.
Court master, the IA stands disposal. For admission, item number 3. Yes, compliance affidavit.
May I please, your lordship? Your lordship, I agree with your lordship.
I think the order of this court is very clear. It
Yes.
is just to be clarified that since the matter pertains to the year 2019,
Yes.
compliance affidavit, if any, shall be positively filed by the next date of listing, failing which adverse orders including direction for personal appearance shall be
Your lordship, I agree with that. Your lordship, here is a very peculiar case involving two ethnic community. So if the state government taken any hasty step or misstep is taken, then there will be a widespread communal clash. So your lordship, unless the court was gracious enough to grant time.
Mr. Counsel,
Yes, your lordship.
please appreciate that this is a
Lordship.
contempt petition. The orders
Yes.
have already been passed by the court.
Yes.
If you
Lord-
have any grievance, if you have any difficulty in implementing the court's order, you could have approached the court. There is no stop for it. But you
Lordship.
cannot be sitting over the court's order. You cannot flout the orders of the court in this fashion.
Lordship,
And this matter is pending since 2019.
lordship, I agree.
Till date, you have not complied.
Your lordship, the problem is,
This cannot go on in this fashion. This is a contempt
I agree,
proceeding.
I agree with
Please,
that.
please, you are an officer of the court as well, right?
Lordship,
So
lordship, I
it is the
agree.
duty of all of us to ensure that the orders
Yes.
of the court are complied. How can the respondent authority sit over the unambiguous and clear orders of the court?
Lordship,
And that too in the contempt proceeding, such careless attitude? Why no affidavit has been filed till date?
Your lordship, I may be allowed to keep a brief submission. Yeah,
You
lordship.
can go on making submissions, but you see, Mr. Counsel, the order of this court was very clear.
Yes, I agree with that, your lordship. But the problem on the part of the state respondent is that it's a very sensitive issue. That's why we are,
If it
We're in
if
between.
it is a sensitive issue,
Yes.
if you take recourse to law, why are you not complying with the court's order and doing nothing in this contempt petition?
yes, your lordship, I agree with the observation given by your lordship. But your lordship, here, my humble submission before your lordship this morning is that the state respondent, we are going to rehabilitate the two
The
displaced.
state respondents will.
To rehabilitate those displaced person.
They are going to rehabilitate.
Yes, so I will be allowed to place this. Your lordship, here, we have filed so many affidavit and we have complied with so many direction. The only parties to restore to displaced person and the village. This village consists of two community. So as per the direction of the honorable court, we want to restore those displaced person in the village. But since our effort could not be
Yes, ma'am.
materialized.
Say,
Lordship, they have been saying this for quite some time, Your Lordship.
that's right.
No, this is a loss of effort, Your Lordship. We have been trying to restore
All
all
right,
this.
this court will give you some time, but you please try and complete it. It cannot
Lordship.
go on like this.
Lordship, I agree with that.
Your name?
MTMSO,
Mr. So-and-so learned counsel, for the respondent number,
all the
for
respondents.
the respondent stroke contemners, submits an instruction received from the secretary to the government of Nagaland dated 6/11/2024 to the effect that
Like second page.
that the secretary to the government of Nagaland has directed the deputy commissioner Kipari to discuss with the United Santam Likhum Pumji and Eastern Sumi Hoho to initiate the process for rehabilitation of the displaced persons from Sioching village
Lordship.
and to submit action taken report. Stop. In view of the said development, this court is pleased to adjourn the hearing of the present contempt petition for a further period of 4 weeks. Stop. However, in the event, no, it's all right. A copy of the instruction dated 6/11/24 is kept on record. List accordingly, huh? List accordingly. Yes, LCR has received. This is a first appeal.
Yes, sir.
LCR has received. So I'll be posted for hearing.
Yes, sir.
Okay. Heard so and so. It appears that the trial court records has been received. Stop. Since the matter is ready for hearing, let the appeal be admitted and listed for hearing. List for hearing in the due course.
Oh, Your Lordship, there is an interim.
Interim, if any, shall continue till the next date of listing.
Item number 5.
This is an application under section 34.
Yes, my lord.
How is this filed? Please satisfy the court. How an 34 application has been preferred in the High Court?
My lord, in the recent
You have an arbitration act.
Yes, my lord.
Please read section 34. Yes, please read section 34.
My lord, application for setting aside arbitral award.
Yes,
Subsection
please.
1. Recourse to a court against an arbitral award may be made only by an application for setting aside such award in accordance.
All
with
right, one
subsection
second
4.
now stop here. Now come to the definition of court in section 2. E. Read 2E. Yes, please read.
Yes, my lord. 2E, court means in the case of an arbitration other than international commercial arbitration, the principal civil court of original jurisdiction in a district and includes the High Court in exercise of its ordinary original civil jurisdiction, my lord. Having jurisdiction to decide. Yes, my lord.
The question, forming the subject matter of the arbitration if the same had been the subject matter of a suit. Stop. So you see, unlike Delhi, Bombay, Gauhati High Court does not exercise ordinary original jurisdiction. So how can a 34 be maintainable before the High Court? You go to the district court. Your court is the district court, not the High Court.
My lord, it includes the High Court, my lord, in the definition
Mr.
itself, my lord.
Counsel, I don't think there is any scope of argument. Please read it again. High Court in exercise of what? Ordinary.
Civil jurisdiction, my lord.
This, are you trying to suggest that the Gauhati High Court has ordinary civil jurisdiction? Are you suggesting that?
My lord, I have a matter even in Delhi High Court. My
Because
lord,
Delhi High Court has original civil jurisdiction. Bombay High Court has original civil jurisdiction. That is why those there a 34 can be maintainable. Please be clear when you file an application. Just because one files in Delhi doesn't mean you'll file in Guwahati. You
my
have
lord,
to
keep a short
understand.
date, my lord, then.
Sorry?
My lord might kindly accommodate the short date, my lord.
What is there to accommodate? Either you withdraw or I dismiss. You withdraw and file it before the appropriate forum.
My
And if
lord, my lord, accommodate me a short date, give me a short date, I'll
there
take
is no
instruction.
question of accommodating. Matters cannot be kept like this. There is no scope of argument, Mr. Counsel. You cannot rewrite everything now. Yes, please take down. Are you withdrawing or dismissing?
My lord, I'll come back with an instruction, my lord. Accommodate me a short date, my lord.
What instructions will you come? Would you confer original civil jurisdiction to the Guwahati High Court? Will you get some notification? What instruction? This is a, you see, Mr. Counsel, please
My
understand.
lord, my lord, I'm a junior counsel, my lord. My
No,
lord,
that's
my
all right. Your
my
senior
lord.
cannot improve the situation unless and until the status of the Guwahati High Court changes. You see, accommodation, these courts are always liberal in giving accommodation. But there must be some justifiable reason. In a case like this, which is not maintainable, on the face of it, you cannot change anything overnight.
My lord, might kindly pass over the matter then, my lord.
I'm keeping it. You take your instructions. I'll take it up as the last item.
My
That
lord.
is the accommodation I'm going to give you.
My lord.
Call it at the end. Yes, next.
For admission, item number 6.
Appointment of arbitrator.
Yes, your lordship. May I please, your lordship?
Notice was issued. Any objection?
No, my lord, I'm appearing on behalf of K. Angami. I'm informed that he is yet to receive instruction.
All right. Mr. So-and-so, learned counsel, appearing on behalf of Mr.
K. Angami.
K. Angami, learned counsel, appearing for the respondents, submits that the respondents are yet to receive instructions to oppose the prayer for appointment of arbitrator, and accordingly seeks accommodation in the matter. Stop. Prayer is allowed. List after 2 weeks on a date to be fixed by the registry.
Much obliged.
For orders, item number 8.
Made to your lordship. So this contempt
Yes,
matter
Mr.
was
Sharma?
contempt matter was preferred for non-compliance of an order, whereby there was an order for payment of compensation.
That has been done.
That has been done. So it has been substantially complied with, and so therefore the petitioners do not want to pursue it any further.
All right. Please write. Heard Mr. A. Sharma, learned counsel for the petitioner. Stop. Also heard Mr.
LD Sanctum.
LD Sanctum,
Yes.
learned
Additional AG.
additional AG appearing for respondent numbers. All.
Not all, it will be
Deputy Commissioner Pack.
3 and 4.
Respondent numbers 3 and 4.
3 and
What about the others?
The others, there was already a compliance
All right.
from them. So it
Stop.
was the
by-
state who was opposing to this payment.
No. By way of this petition under Section 11 and 12 of the Contempt of Courts Act, read with Article 215 of the Constitution of India, the petitioner is drawing attention of this court, the alleged deliberate and willful violation of judgment and order dated 31/2023, passed by this honorable court in PIL number 9 of 2019. Stop. Today, when the matter was called, Mr. A. Sharma, learned counsel for the petitioner, submits that the aforesaid order dated 31/2023 has been complied by the respondent authorities by, you said some payment was done.
Yes, the payment has been done. The
What
compensa-
payment? What compensation?
Compensation, land
By-
compensation payment.
By making the,
Land,
by making the by making the requisite land
land
compensation.
damage compensation.
Land compensation, land damage
So
compensation.
there were some damages that took place. It was compensation for that.
Stop. In view of the aforesaid endorsement made by the learned counsel for the petitioner, nothing survives for adjudication in the contempt petition, and accordingly the contempt petition stands closed.
Oblige, Your
Lord,
Lordship.
with your apology, I appeared on behalf of respondent number 4.
Only
Not 3.
4.
Only
All right.
4.
Disposed of.
Oblige, Your Lordship.
For orders, item numbers 9 to 14.
Service is complete.
Lordship, service upon last occasion.
It was waiting. Is it
Mr.
still awaiting or it is complete?
No, Mr. Lordship, in respect of respondent number 1. On last occasion, that is on 21/10/2024.
I think 1 to 5 is delivered. Postal receive and track consignment of the contender 1 to 5 is placed. Track consignment indicates delivery confirmed. You are appearing
My lord, I'm
Or-
appearing for 3 and 5.
3 and 5. Service, as per this, I think is complete.
It's complete.
Office note dated 27/9/24 indicates that the service upon the contender number 1 to 5 is complete. Stop. Mr.
LD
So and
Sankar,
so learned counsel enters appearance on behalf of respondent number
3 and 5.
3 and 5.
Yes.
Stop. However, there is no representation on behalf of the other respondents stroke contemners despite completion of service. Stop. Be that as it may, let this, no, don't say that. You will file your.
Yes, my lord, I have received instructions.
Mr. So and so further seeks 2
4
weeks' time.
4 weeks.
4 weeks' time to file return in the matter.
Yes, ma'am.
Prayer is allowed, list after 4 weeks on a date to be fixed by the registry.
Much.
Your Lordship, item number 9 to 14 are analogous.
Yes.
For hearing, item number 15.
This is that inquiry
My
matter.
lord.
Chesi, I had already given an order in this, a draft order. I think Mashwai has it. The facts were already. Yes, I had had a look at the inquiry report.
May I please, Your Lordship?
Yes.
My lord, I'm mentioning on behalf of S. Mary, PP. My lord,
Yes,
she,
PP has
she's on,
Given us as the inquiry report, and this court had asked if there is anything more.
my
That's
lord,
all.
my lord, she is in bereavement, and I'm informed that there is no new development as such, my lord.
There is
Till
no
date.
new development.
Yes,
Then I will dispose of the matter. The inquiry report is already given to the court. The inquiry report is before the court.
My lord, let the matter be listed on Monday.
I'm listing it on Monday, but Mr. Counsel, please be mindful, this is a part third matter, so
Yes.
I will not be going on adjourning the matter.
Okay.
Everything is before the court. In
Yes.
fact, half of the order has already been typed out,
Yes,
correct?
yes, ma'am.
So the only thing that the court wanted to know is anything addition in there.
Yes,
The otherwise, the inquiry report is very much in front of the court.
yes,
The court can go ahead with the matter. But since you are mentioning, I am
Yes.
posting it on Monday.
Monday, yes.
But I'm making it very clear that no further adjournment shall be given.
Okay, ma'am.
And in case anybody is not well on that day, ensure that alternative arrangements are made.
Okay, ma'am.
These are not grounds on which these matters will be kept on adjourning. I'm making it very clear. An adjournment has been made despite the order being fixed today as a part third item on the ground that
S. Mary,
S. Mary Learned PP
PP, yes, ma'am.
is in bereavement.
Yes.
Stop. In view of the aforesaid ground for adjournment, this court is posting this matter again on Monday date, so and so date. Stop. However, it is made clear since the matter is part heard, no further adjournment on Monday shall be granted. In case of any difficulty in the part of any of the counsel arguing the case, alternative arrangement shall be made.
Interim order.
Much.
Interim order passed earlier shall continue till the next date of listing.
Will my lord do the matter through video conferencing method?
You don't need an order from this.
My lord.
CGI has made it very clear.
Right.
Any application for online has to be given.
Right.
You want to do it online, you
Right.
can do online, no
Right.
worries.
My lord. Hello.
Much obliged.
For hearing item number 16.
This is that POCSO matter.
Yes. My lord,
Informant.
I have,
Huh?
I have found a non-fiction.
For
Whether the.
issuing notice
Yes.
to informant.
Yes.
Yes, that is in, I think that, in terms of that, decision, Deepak
Correct,
Nayak.
correct.
Yes. So then we'll issue
Now-
that notice.
No, Lordship, only one small thing is, my lord, this was filed in 18, whether this
Whatever,
had
what-
retrospective.
It doesn't mean, in any matters, it is very clear.
No problem.
You see, it says in every bail application, criminal appeal, the
Yes,
registry shall serve a copy.
yes,
So now it
Well-
has to be given.
yes.
All right?
No,
Yes, please take, Hurt so and so. you
Mr.
give
K.
his
Go, my
name.
lord.
It appears that the instant criminal appeal is arising out of offenses under the POCSO Act.
Yes.
Stop. In view of the decision of the of the principal bench, of the division bench in criminal appeal J 40 of 2022, in the case of Deepak Nayak versus State of Assam, comma, it is imperative to issue notice to the informant before taking up the criminal appeal for hearing. Stop. Pertinent to mention that pursuant to the direction of the division bench, comma, the Gauhati High Court has issued notification dated 15/3/2024, whereunder it is imperative, whereunder it is mandatory that in every criminal appeal involving offenses under the POCSO Act, comma, copy of such criminal appeal be served to the public prosecutor concerned, who shall in turn forward the same to the investigating officer concerned to apprise the victim stroke guardian stroke support person regarding filing of such proceedings before the High Court. Stop. Relevant portion of the notification number 17 dated 15/3/2024 is reproduced hereunder for ready reference. A to A, huh? Next, in view of the above, who is the informant, the related?
The guardian, my lord, local guardians.
What is the relation?
Actually, the alleged victim was working in his house.
No, what about the parent?
Parents are not from here, they are not, no. They are not parties here.
Guardian, it says.
Yes.
POCSO.
Yes. Keso.
In view of the aforesaid, comma, let copy of the criminal appeal be served to the guardian of the victim, i.e. Shri K. Soho, through the jurisdictional police station. Stop. Let a copy of the criminal appeal along with the paper book be furnished to the office of the public prosecutor in order to facilitate the public prosecutor to forward the same to the jurisdictional police station, to enable the officer in charge of the jurisdictional police station to serve the same to the victim stroke guardian through, to the guardian of the victim. Stop. Let a report, no, in that you say, the notice shall be given in the form prescribed by the principal bench. Stop. let a notice of service be thereof be submitted by the jurisdictional police station to the office of the public prosecutor thereof. List the matter after 2 weeks on a date to be fixed by.
Lordship, make it 3 weeks.
3 weeks.
Yes.
This notification is there, huh? Chelsea, you want it? Keep it back in the file. All right.
Make it 4 weeks, my.
All right, 4 weeks.
The district is little far.
Should be impleaded because
No, I agree, no problem, no harm.
I will see, I will edit it. If
Well-
required, I'll implead it also.
Yes.
4 weeks.
But otherwise, the basic purpose is the presence. The
But-
participation is now required.
That much, my lord.
All right.
Much of that.
Yes,
For hearing, item number 17.
yes, Mr. Devnath, you are physically present today. Yes.
Lordship, before my learned friend begins, I have raised some preliminary objection on this appeal.
Yes, what is it?
Lordship, the first thing is that the appeal has been filed without the permission of under 170B.
You have objection to the maintainability of the appeal.
Yes, Lordship.
Any objection filed?
I have filed, yes,
You
Lord.
have filed?
Yes.
It has been filed.
Yes, yes.
And the second one is that they have raised a new issue which was never raised before the learned tribunal.
But this is a MAC appeal,
Megapixel.
so it will be heard. You will get your chance to
Lordship.
object whatever you want to object.
Lordship.
Preliminary issue is not required to be made. Is it required for objection?
Lordship,
Not required, Lordship.
if
not
that is
required.
decided, other things may not be necessary to go
Correct,
into.
but
Otherwise,
And Lordship, this is the first appellate court. The Lordship has the discretion to take it, Lordship.
no, but they are having a objection to the maintainability. What is
Otherwise,
the objection?
Lordship, may I continue then? Lordship, I'll take your Lordship to my objection. I have filed it, Lordship. Lordship has found it, my objection. This is my written objection. With opposite party number 1 and 2,
I am
claimants.
getting the, okay, yes.
Against the main appeal, Lordship.
Yes,
Lordship, in my bara 2 and 3, I have stated, Lordship, first thing is,
no
The-
permission under 170B.
yes, no permission under 170B was granted, or nor any application filed by the,
All right, let us see one by one. Let us see 170. Let us see 170.
oh, Lordship,
You're not carrying the act.
no, Lordship, I'm handicapped today because my junior.
Then another day, you must come prepared with all your barracks. List on,
Tomorrow then, Lordship, or,
Lordship, not
tomorrow
tomorrow.
will be difficult.
Lordship, next week.
but Lordship,
Which, tell me when next
Thursday
week,
next,
list again on such and such date.
Thursday, Lordship.
All right, Lord.
But please be prepared with the basic barracks and come to court. If you
I've
are
come in
hearing
my,
matter. Anyway, I'm
then-
accommodating you today, but. not
last minute,
always.
my junior did not turn up, Lordship. So I on it.
Yes, next.
For
matter.
hearing, item number 18 to 20.
Yes, what is this writ petition?
This is a matter pertaining to the order passed by the Lokaayukta. So we are challenging the order passed by the Lokaayukta, that is 19/12/2019. When the order.
Cause notice was given or what?
Yes, my lord.
What is the order? This matter was earlier heard in part and then
Yes.
released.
Yes, my
Right?
lord.
I see a lot of notes and everything in the file.
Yes, my lord.
Yes.
Here, my lord, if Your Honor, we appreciate it's a covered case. There is a similar order. An order.
Covered case, we shall come, but first tell me what is your case?
Yes, my lord.
Yes.
So the impugn order is 1912-2019,
Hmm.
wherein the learned court below has given a direction to the respondent.
This is a writ petition.
Yes, my lord.
Learned court has given direction, meaning?
Lokayukta.
Or, yes.
Yes. The
Yes.
Lokayukta has given in order to the respondent number 3, Deputy Commissioner, to cancel the land bata which was issued in my name.
Yes.
So here, my lord.
To cancel the patta.
Yes, my lord.
This is what you're challenging now.
Yes.
Yes.
So,
And what is that covered case you are saying?
yes, my lord.
Is it covered?
No, your lord. Now, in the impugn order passed by the Nagaland Local Court, your lordship, there are two parts, part 1 and part 2. So far as part 1 is concerned, your lordship, initially it was challenged in another writ petition, your lordship, a batch of writ petition, where part 1 was challenged. Part 1 relates to dismantling of government quarter, and the part 2, which relates to this writ petition, is in respect of issuance of irregular land patta without permission from the court, approval from the, sorry, lordship,
there are
from the government.
Parts. One
is regarding dismantling of condemnation and dismantling of government quarters,
dismantling of government quarters.
lordship. Condemn first and then dismantling. And the second part, condemnation because of depleted condition, your lordship. Condemnation and dismantling of government quarters.
And number 2?
Number 2, so far as this writ petition is concerned, relates to illegal issuance of patta, land patta, over which the government quarters are standing.
All right.
Now, your lordship.
That case which Land Council is relying covers the first part.
Yes, your lordship. And initially, both the writ petition were clubbed together, but subsequently, because that the issues are different, it was separated, your lordship, when that first part was taken up.
So first part, there is no quarrel at the bar.
No.
That it is covered.
Yes.
As regards dismantling of government quarters.
Lordship, because the issue here is whether Lokata can give direction. Whether Lokata can give direction or it's only a recommending body. Now, first part, in part 1, a direction has been given specific. But so far as this part 2 is concerned, your lordship, it is only a recommendation, lordship.
Which is within the power and ambit of the Lokaya.
So based on the recommendation, Deputy Commissioner has issued a show cause notice.
Where is the order? Page 59.
It starts from page 57, my lord.
This is the order under challenge.
Yes.
The Lagan and Lokayukta Kohima.
May I read it, my lord?
Yes, please.
The Nagaland Lokayukta Kohima case number RC2 of 2013 before Sri Mayang Honorable Opal Lokayukta order 1912-2019 part 1 Ramban contamination and dismantling of PWT quarters in Dimapur. This case has originated from the letter dated 24/9/2013 received from Undersecretary to the Government of Nagaland Department of Work and Housing Branch, requiring the 10 State Vigilance Commission, now Lokayukta, to inquire into the matter of rampant contamination and dismantling of PWT Department quarters at PWT Colony, Dimapur. Accordingly, an FIR was registered against Engineer Keshitu, now deceased, STO H3, Dimapur, and other under Section 409-120 PIBC. During the course of the investigation, the Nagaland Lokayukta police, led by Srimati Opolomi SP, and her investigation team established that late Engineer Kishitu STO PWD Brigade H Dimapur has issued 45 numbers of right-of survey report against PWD quarter at Dimapur, and Engineer Gauhati, the then EA PWD H, had approved the following 42 numbers of survey report of write-off of the PWD quarters. So the serial number 1 to serial number 42 is the quarters.
All right, come to the order.
Yes. Page 59, my lord.
Yes, please.
Yes. In view of the aforesaid facts and circumstances, the prosecution had failed to prove the charge for the offense punishable under section 409 IPC, read with section 13, clause 1, subclause C and 2 PC Act 1988.
What are you aggrieved from this order?
My lord,
The order, your lordship, starts from page 60, is page 60.
Page
Page 60.
60.
Accordingly, the Department of Works and Housing branch is hereby directed to.
Yes.
So a direction has been given. So this has been interpreted. We considered.
Read the direction.
60. Page 60. Accordingly, the Department of Work and Housing branch is hereby directed. So we are saying that this is direction in order, not recommendation.
Correct. So this direction is already interfered by this court,
Yes.
right? And they are conceding to that
Yeah,
part. Now,
yes.
which part is the second part about the illegal
Yes.
issuance?
Page 61, my lord.
Part
Part 2. Now the
Now,
question
is
of
this a direction or recommendation? Let us
this is
see.
all, yes. This is also a direction.
Let's see. Read.
Yes. Part 2, irregular issue of pata, regularization of land extension and mutation of pata in PWD Colony Timor by the Office of the Deputy Commissioner. During the verification of occupants of the PWD quarter and pata holder of the land where there is standing PWD quarter in PWD Colony Timor, it was established by Lokayukuta Police investigation team that each of the PWD quarter occupants were in possession of either regularization order, settlement order, extension order, rectification order, mutation order, Chamapanti, Patapok, and other orders. Each of them claimed that the land was allotted from the Deputy Commissioner Office, Timor. They also stated that the pata were issued against the standing government quarter. As such, the land belonging to them and not to the PWD department. On scrutiny of the documents received from the occupants of the PWD quarters at PWD Colony Timor, it was found that the below mentioned 65 files were used to issue regularization/extension order by the Deputy Commissioner Timor office. So the column indicates 65 persons.
Yes.
Yes. And out of this, my name is.
These are all findings. Where is the direction? There's no direction.
My lord, to that I'll come, my lord.
Where is it? Show me that.
Page 64, my lord.
Yes.
Just above the column.
Yes, based on.
Yes.
Yes.
Based on the aforementioned fact that has been established by the investigating team, the following patas are to be cancelled by the Deputy Commissioner.
It appears this is in a recommendation because it says by the DC Dimapur after following procedure.
My lord, here, one crucial aspect. My name is reflected as serial number 3 in the column.
Yes.
Here,
Document is in possession of a cancelled patta.
yes, this is totally false.
No, but you see, the DC
yes,
has to follow the procedure.
yes,
So at that time, you can show whether you have, you are possessing a cancelled patta or whatever. You will have the opportunity.
yes. So the Deputy Commissioner, they have issued a show cause notice, which is also under challenge.
Where is that show cause notice page?
So in this particular petition,
You see, the wordings could have been different.
Yes, my lord.
It could have been that
No.
based on the aforementioned facts, it could have been said that it appears that there are anomalies and recommendation could have been made.
Your lordship may kindly come to page 73.
Yes, I have 73.
Page 73, just below the table.
Yes.
Before any recommendation is made, it starts with this sentence, your lordship. Before any recommendation is made.
Yes.
So from here only the recommendation starts, your lordship. And the recommendation part, recommendation is page 75. Page 75
Yes,
in bold.
yes,
In DC Dimapur, in bold it is there, your lordship,
is to take action.
is to take action on the cancellation of patta as mentioned in page 8 such and such, and conduct thorough verification on the cases pointed out in page number this of this order, and streamline the system and submit report to this court within 30 days. It is recommended that
When the DC takes action on the cancellation of patta, it has to be done in accordance with law.
No.
If you want, I can make that clarified. But I don't think this court is going to interfere with the second part of the order, because it appears it is record. It's a fact finding. They have done an inquiry. They have stated what they have found, and at the end they have made a recommendation, which appears to be in conformity with the provision of law. Yes, please give me the provision of the law. Lokayukta. Yes, which section? Nagaland Lokayukta Act? or
Nagaland Lokayukta Act.
Which section?
It would be 25 if I'm not mistaken.
Yes.
For lordship, if it's there, your
Yes, I have.
yes, section 25, your lordship.
Yes. Yes, please read.
I have 3, your lordship.
3. Yes, please.
If after investigation of any action involving an allegation, the lokata or upalokata, as the case may be, is satisfied that such allegation is substantiated either wholly or part, he shall make a report in writing, communicate his finding and recommendation.
Yes, he's done that. What is wrong?
My lord, I'll come to the point if you allow me to
Yes,
submit.
yes.
Here, the effect is that the relevant portion of the page 74, which my learned friend is also make a reference. There, I'm indicated. It's real number 3.
Serial number 3 at page 74.
No, 64, my lord. Sorry.
64.
Yes. This is the finding given by the Lokayukta. Page 64.
Yes. Occupant is in possession of a cancelled patta.
Yes.
Yes.
So, at the time of the investigation of the criminal case RC 2 of 2013, I, as a person, during the investigation, the IU came and collected my land documents, everything. That he wished to retain the documents. So, on Caesar list, I've handed over the land documents, which I was holding a valid land patta. It is annexed with my writ petition also. Therearound the investigation was carried out, and later on in October 2019, the case was disposed of. That RC case was disposed of. And after that, only the issue came up, and I have never been examined by the Lokayukta at any point of time, nor I have been summoned to any extent at any point of time. At no point of time, I was directed by the Deputy Commissioner or Revenue Authority or by the Lokayukta, otherwise by the investigating agency, that I was holding a cancelled land patta. Till that time, I was holding a proper land patta issued by the Deputy Commissioner. But here by this order, 19/12/2019, indicated
That was against you.
Yeah, this was against me. In my personal verification in last 2 months back, I went personally to verify whether that this particular patta has been cancelled or not. It has never been cancelled in the record, and I believe that the state government might have filed a report to this extent. So from where my land patta was cancelled, who has cancelled, and how come the Lokayukta come to a conclusion that my land patta has been cancelled?
So according to you, there was no material whatsoever before the Lokayukta to come to a conclusion that your patta has been cancelled.
Yes.
Correct?
Yes, ma'am.
And in fact, you are saying that as on date, as per the record of right, you are having patta over the land.
Yes, my lord.
It is
That-
still holding.
Yes,
That is your case?
yes, that is my case.
Now, if under the law, is the Lokayukta has to give any notice to you before doing the inquiry?
No, Lokayukta has to say,
Now, but suppose the Lokayukta has given its finding, assuming the findings are there that it's a cancel patta. Now, will is the DC, as a matter of course, the DC can cancel you and remove you, or the DC will have to hold an inquiry where you will get an opportunity to show that your patta still subsists?
yes.
What is the procedure
So-
before the DC?
Mm. So,
Are you following what I'm saying?
yes, yes.
Because the entire question boils down to that.
Mhm.
You say that you still have the patta,
yes,
and till now nobody has seen your papers. You have not got an opportunity.
yes.
But and the recommendation of the Lokayukta is to the deputy commissioner, saying that is to take action on the cancellation of patta as mentioned in page so and conduct thorough verification on the case pointed out in so of this order and streamline the system and submit report.
Yes,
So there has to be a verification.
yes,
Now, in that verification, you will get an opportunity.
very much, my
So
lord.
in that opportunity, you show that the patta is still subsisting and it is not a cancelled patta. Then
My
how
lord.
are you prejudiced?
My lord, I'll
Because you see, this is only a recommendation.
my lord, I'm saying it's in order. If your lordship.
No,
would
what I am
appreciate-
saying is
yes.
because you see, in front, there is nothing, unless of course you show me that you have a right to be heard
Yes.
at the Lokayukta, while Lokayukta is making that inquiry. If you have a right, I will straight away set aside this order of the Lokayukta. But if there is no right in contained, maybe because it is a recommendation, the DC has to take the necessary steps, and the DC has to take these steps after hearing you. It is already indicated, thorough verification.
Yes. So, my lord,
So you see, what I am saying is that I can clarify this in my order and say that the deputy commissioner will give you an opportunity to show. You can, before the deputy commissioner, you can show all the documents in support of your claim. And after hearing, he will do whatever is required to be done in accordance with law. This is one way.
yes,
Because that way your grievances will be served. You are not saying that because you're not arguing anything beyond what you just argued before me, right? Two things you have said. One, as on date, record of rights, your name stands.
yes,
Patta is in your name, correct?
yes,
And you have the valid documents.
yes.
Show it to the DC.
My lord, that's why I'll come to one aspect.
No, I'm trying to cut short, sorry.
All right, all right, all
Because you
right.
see, at the end of the day, what is important is what is the order which has to be passed, because that order has to serve justice to the litigant, right?
Very much.
So if that is your grievance, I think this order will be perhaps the best. Unless you want to say something, yes, please.
Yes,
please.
I live with the wisdom of
No,
this honorable
because
court, but I'd like to come to certain.
all right. I am also,
issues.
you see, the point of
Yes,
speaking out is speaking out of your mind to give you an idea what is going on.
yes,
So if you both concede to that, I can dispose it right now with that order.
yes, my lord.
Yes.
So, show cause was issued as to why my land bata should not be cancelled.
So in reply to that show cause notice, you'll have to give the documents, you file a reply.
Yes, yes, I
giving
filed,
all-
I've annexed with the writ
Yes.
petition. I've
So-
annexed with the
so
writ
I will
petition.
record that also. So
Yes.
the DC has to consider all this. He cannot, as a matter of course, cancel your patta.
So,
Where is the show cause? Page?
yes, reply here in this
No,
particular.
no, show cause notice is where?
My lord, for this particular petitioner, the
You-
show cause.
You have not annexed?
Misplaced, yes, but the reply is given.
I have seen, page
Page
77.
48 show cause.
Show cause is there. Court master, can I have some more flags, please?
Yes,
Page?
Page 48.
We add annexure 20, my lord.
And
You see, It's a clear cut because you have already replied.
Yes, my
So
lord.
let him consider
But
everything. And I will add one more thing. To give you an opportunity of hearing,
Yes.
you appear,
Yeah, for that I have no issue.
isn't it?
But my lord, here, after we file a reply also, there was a commotion that we are supposed to be forcefully evicted.
No, that
That is
we
one
will
aspect.
take care.
Yes.
This court will take care of that situation.
And and the other aspect is that if I leave it to your wisdom of this honorable court, but here, if we are
Operative
to,
part, page 50.
if we are to look into the aspect of this particular impugned order that under challenge, that is under challenge.
Just below the table. Further this office.
Page 57, if your lordship can kindly make a reference to page 57.
1 second, please.
All right.
Yes, it is already given. This show cause notice is very much clear. You have been directed to appear before the office within 15 days from date of receipt of the order with all relevant documents in support of claim. You show everything. The DC is not cancelling it without hearing you.
As on date, no legal rights of the petitioner has been
my lord.
infringed.
From where the Lokayukta has come to conclusion.
You see, whatever the conclusion of Lokayukta be, the DC is not accepting that with closed eyes. That is only a recommendatory body. They have made recommendations, correct? They have made recommendations to the Deputy Commissioner that you take action in accordance with law. Pursuant to the recommendation, Deputy Commissioner has issued show cause to you to show that you have valid documents. By appearing, you have already submitted your reply. You appear on a scheduled day. This court will clarify. You show the documents. After seeing the document, the DC will pass the necessary order. If you are further aggrieved by that order, you can always come to the court.
That liberty we have.
That liberty
Yes,
you always have. You will
Yes.
always have. You
Yes.
don't need a liberty from this court, isn't it?
Yes.
Because if you have
I-
the documents, then why do you fear? If you have the documents, then you don't have to fear.
Yes.
You're not going to be evicted without due process of law. In fact, the show cause is very clear that you appear with all relevant documents in support of your claim. They are not accepting the fact that you are possessing a land which is already cancelled. Patta is cancelled. They are not accepting that position. They are giving you the opportunity to show. Correct?
Yes, I agree to that, my lord.
So then,
But if your
No, I
lordship
don't think-
would
sorry.
appreciate page 57, kindly make a reference to.
yes,
just
yes,
page
for your
57.
satisfaction, I'll go back to 57.
Yes.
57 is
And
uh,
order. It is
you see,
crystal clear, it's in
no,
order.
57 order, this is relating to the other part. But when you come
Yes.
back to
No,
page,
part two,
yes, you
yes,
come to page 75.
yes.
That is the recommendation.
75, so I may be allowed to read out the portion which is very much relevant. Just
From,
below,
from,
from page 75, just below the
Yes.
ST Lalthara, Chief Secretary to the Government of Nagaland. Just below that,
yes,
it starts.
yes.
Thus, all the land allotment without the prior approval of the government by various administrative officers in Dimapur has violated standing orders. In fact, the office memorandum dated so and so is that all allotment of government land made to private individual irregularly.
These are the various orders.
Reproduced.
Correct.
Yes.
Now you see, Mr. Counsel, there is no point of reiterating these observations from here because you have already shown me the show cause notice issued by the DC.
Yes.
Has the DC accepted this with closed eyes? The DC has given you the opportunity.
My
You
lord,
go before the DC and show the documents.
if
All that you need to show is your valid documents. If you have documents in your support, matter rests there.
my lord, then I may be allowed to give a small submission.
Yes.
The Lokayukta is to give a recommendation
That we have given.
to the government, not to the Deputy Commission, to the government, either to the governor as well as otherwise to the appropriate authority. Whether the Lokayukta can give a strict direction to the respondent number 4. That is one question which we have to look into as per the act. Act does not says that the Lokayukta has to give recommendation to the deputy commissioner. It has to go to the state. And the state has to give a direction to the appropriate authority as to how they have to go ahead. So that is what we are also challenging, that we are saying that Lokayukta has no power to
To the competent authority concerned,
yes.
this is the competent authority.
Lord, so far as land allotment of land is concerned in the district, Lordship. And if at all it is to be challenged, it is to be challenged by the DC because this is no can.
No, who is the competent authority?
Yeah, allotment of so far as allotment of land is concerned, Your Lordship, it is the deputy commissioner,
Deputy commissioner.
respected
So
district.
in paragraph 3, it is given, if after investigation of any action involving an allegation, the Lokayukta or Lokayukta, as the case may be, is satisfied that such allegation is substantiated, either wholly or partly, he shall by a report in writing communicate his findings and recommendations along with the relevant documents, materials, and other evidence to the competent authority concerned.
Yes.
So he's given.
That is that. But
You see, Mr. Counsel, I don't see any case. That is why I'm saying instead of going into the merit of all this, which might unnecessarily prejudice one of you, I can simply say that it is disposed of. However, needless to be clarified that you would be given full opportunity. I may say that. And in the event you are aggrieved, your liberties are open to approach appropriate forum.
Until such time, he will not be evicted. His
Yes,
position.
I can make sure of that also.
that to that extent, if the court safeguards my position, I have no
So then
issue.
I'm
But here,
like that.
I would like to make a reference. Since I've cited a
No, you
covered,
see, if
covered case.
Where is the covered case? Please give. That is on the first point, right?
I'd like to take your lordship to page 24.
Yes. Yes.
Yes, page 24. Date of hearing in judgment. 35/2020.
That's all right. You please read the operating part.
Yes,
Para 21.
para 21. Under the fact and circumstances aforesaid in the discussion made, this court is of the considered opinion that the impugned order 19/12/2019 passed by the learned
So
Lokayukta.
direction cannot be given.
Yes. Lokayukta, so far as it constitutes a direction, is unsustainable in law. Further, the consequential action taken by the department in the form of order number so and so is unsustainable and accordingly set aside. So here,
You are for the Lokayukta.
Yes, I
You
consider.
have considered.
I
have seen
consider.
Paragraph 18.
Yes.
so my lord, the names of the petitioner who are listed in this case, their name is also been included in part 2. What we have been referring.
I've seen serial
Yes.
number.
So
3.
I'm saying that this order is a very much covered case in my case also. That is what I'm trying to clarify.
Right, I was trying to dispose your case, but you want me to go into all this, then we'll have it on another date. List again on Tuesday.
For hearing,
Much obliged.
item number 24.
May I please, your lordship?
Lordship, yeah, can we have it on Tuesday? I have one fixed matter for court number 1.
Monday.
Or Monday or Thursday. Wednesday is DB or
All right, Thursday.
Thursday, Your Lordship. Much obliged, Your Lordship. Much obliged.
Yes.
Lordship, informed by the respondent counsel that he's engaged in district court since.
Which matter?
24, lordship.
24. As it is submitted at the bar that Mr.
Yangawati.
Yangawati, learned counsel for the respondent, is engaged in is engaged before another court and accordingly seeks accommodation. Stop prayer is not opposed. List after 3 weeks on a date to be fixed by the
Lordship,
registrar.
can it be fixed next week?
No.
Obliged, Lordship.
Lordship, my apology, Lordship. In item number 22, there is an interim, Lordship.
Where?
Item number 22.
Take down the order for 22. Inform whoever has taken to add interim, if any, shall continue till the next announcement.
Deeply obliged.
For hearing,
Yes, Mr.
item number 25.
I'm for the respondent.
Item
I
number
had the 25.
25,
Five.
testimonial appeal.
This is an appeal against the grant of probate
Yes.
by the trial court. On earlier last
Your
year,
name
my
is not there for the respondent.
Initially, it was not there, but subsequently, Wakalatnama has been filed.
All right.
last year, my lords, we had argued this matter at length, and I had concluded my arguments. But the matter was also reserved. But somehow Mr. Paul could not argue the matter, and therefore the matter
You
was
said
be
Mr.
reserved.
Paul, but he is not Mr.
No,
Paul.
that time Mr. Paul was there. That time
got
Mr. Paul was there when I had argued the matter on last occasion. But now again, I have the privilege to argue before your lordship about this
The
matter.
matter will take time.
My lords, I'll not take more than an hour.
That is okay, because why I asked is because as you are aware, I'm here only for 2 weeks.
My
So
lords,
this
that would
week is
suffice. I think so. That would
This week has
suffice.
already come to an end.
Oh, that period is coming to an end.
This
No,
week,
no, this week is
this week
ended.
has already ended.
My lords, I think so. I'll be concluding it
All
within
right.
an hour, and he may conclude thereafter.
All right.
Grateful, my lords, very grateful. Lordship may kindly appreciate that the impugned order has been passed by the trial court contrary to the provisions of the.
One second, 1 second. Yes.
Contrary to the provisions of the Indian Succession Act, complete violation of Indian Succession Act, complete violation of Indian Evidence Act, that how a will has to be proved, and a complete violation of Registration Act, that in what manner I'll show before your lordship that the will was registered. List of dates, if your lordship will see, the list of dates are available in memo of appeal for kind perusal, so that your lordship may have the glimpse of the matter. What is the matter?
You are from here?
I am from Rajasthan, my lords.
From?
Rajasthan, Jaipur, practicing at Jaipur. High Court. List of dates are, my lord, just before, after the synopsis.
Yes.
In the memo of appeal.
Yes.
Now, your lordship may kindly appreciate the first date which I have mentioned is as 6/10/2010.
Yes.
This is a registered will executed by the executant late Shri Kesri Devi in favor of the present appellant in respect to a property situated at District Seeker, State of Rajasthan, and is a registered will as per provisions of the Registration Act. In respect to another property, same Kesri Devi executed another will in respect to a other property again situated at District Seeker, State of Rajasthan, registered on 19/4/2012. So in that way, two wills of two separate properties came to be executed by late Kesri Devi in favor of the present appellants, and they have the interest in these two properties.
So there are two different properties.
Two different.
Both executed in favor of Keshri Devi Sethi.
Yes.
All right.
Then a document which has come on record is a document of 29/6/2012, which indicates a document of declaration of cancellation of those sale deeds having been executed at Dimapur.
Yes.
Then comes into picture
Of both.
Of both. I'll show that how those all documents are fabricated and how after concealing every litigation between the parties without issuing any citation to this appellant, the probate has been obtained behind the back. Then comes into picture a will executed by Kesri Devi Sethi in favor of Manju Devi.
In respect of the two properties.
In respect of 4 properties.
Including
these, one at Jaipur, that again is state of Rajasthan, and no immovable property at Gauhati, no immovable property at state of Nagaland. Only in respect to immovable property, that whatever has been left, my money, my movables, which I have at state of Nagaland or at district Dimapur, I give to them. So only by way of that immovable.
So there is no details mentioned.
No details mentioned.
No details.
No details of immovable
It
property.
is kind of
Residuary clause, we can say so. Whenever we write that whatever is left not written specifically will be also I bequeath to so and so.
All right.
This is the will for which the probate has been granted by the tribe.
Yes.
This will, this is very relevant, executed.
When was probate granted?
I'll show my love, probate.
Yes.
First of all, I'll come. This will of 21/10/2019 has been registered on 23/2019, 2 days after the execution. And the very relevant date is the death of Kesri Devi. Death of Kesri Devi. On the very next day, Kesri Devi expires.
Okay. Yes.
Now, your lordship may kindly see, they started the probate proceedings by filing an application which is at Annexure 2 on 5/10/2022.
That you have not said in your list of dates.
That is not in the list of dates. If your lordship will kindly come to Annexure 2 immediately.
Mr. Gupta, page?
I'm just referring the page. Just a moment. Annexure 2, your lordship will find at page 27.
Yes.
The record is also with your lordship of the trial court, where all the order sheets are there. When this, as per the record, this has been shown on 5/10, but filed on 7/10, as per the record. 7/10/20. And the executor in the will was one Pradeep Jhanjaria.
Yes.
He filed this application before the district court Dimapur for grant of probate in respect to the said will. Now, your lordship may kindly see, he mentions the names of the persons. I'll tell you the relation also. I am the son of the real brother of Kesri Devi. And this beneficiary of the second will is the wife of the adopted son of Kesri Devi and his husband. So, admittedly, there were no legal heirs, natural born son or natural born daughters. Therefore, your lordship may kindly see whom they names as the legal successors, the sons and daughters of the Manju Devi.
Who is Manju Devi?
Manju Devi is the beneficiary of the second will.
Second?
Will, which is of 2019.
By Kesri Devi.
By Kesri Devi. Registered on, executed on 21/10, registered on 23/10, death on 24/10. As soon as it comes to a mind, my lords, that a person writing a will on 21st/10, registering on 23rd and dying on 24th, court has to see, even if it before granting the probate, that whether what was the state of mind of that lady, because it raises a suspicion of dying of a person in a very close proximity from the execution of the document, registration of the document, and death of the document, the person.
So you are challenging the will dated 21/10/19.
I am not challenging the will at here. I am challenging the probate proceedings
in relation to the will dated 21/10/19. Very next day she
expires. The will is executed at Dimapur.
How old was she?
Malats, I will show that. According to me and according to the documents on record, she was 89 years of age.
Was she suffering from any?
She was suffering from ailment.
89.
9.
And what was the nature of the ailment?
But she was suffering from all having strokes, not in her senses, just before 1 month.
Where is the probate order?
Probate order. That's very interesting.
321.
2321, annexure 1.
Let's go there.
Yes, ma'am. Kindly come to that order.
Page
22.
Page 22.
Yes, ma'am. Annexure 1.
This is some written submissions that you had given.
Yes, but written submissions also were given by me because I had concluded my arguments. But the fate of the case could not be
2020.
Page 22, annexure 1.
Yes, I've got it.
This is an application under section 276 of the Indian Succession Act, praying for probate of the will dated of late Shri Kesri Devi Sethi, wife of late Shri Bhajan Lal Sethi. Heard submissions of the learned counsel for Hectoga for the petitioner. The case of the petitioner in brief is that the executor of the will, whom the late Kesri Devi, wife of late Bhajan Lal Sethi, had appointed while the last will was executed, and after registration of the said will by Sub-Registrar Dimapur, Nagaland, by registration number 69 dated 23/9, the same being kept under the custody of the petitioner. It is submitted that the will was duly executed by the testator, late Srimati Kesri Devi Sethi, wife of late Bhajan Lal Sethi, in the presence of the witnesses as named in the will. It is further submitted that the said testator died on 24/10/19 at the house number so and so, Dimapur, at the residence of Amarchand Sethi, and the petitioner is the executor named in the last will, and testator of the testator, late Srimati Kesri Devi Sethi, wife of Bhajan Lal Sethi, that the said testator had affected the place of abode.
Mr. Gupta, you can read slow.
Oh, I'm sorry. That the testator had a fixed place of abode at house number 65, GS Road, Dimapur, Nagaland, under the care of Amarchand Sethi and daughter-in-law Srimati Manju Devi Sethi. That the said testator had
Daughter-in-law.
Daughter-in-law.
So caretaker and daughter-in-law. Manju
That
Devi.
the said testator had left behind the following landed property: commercial land at Shastri Nagar, ward number 15, on the main road of Ashok Nagar Vihar to Rani Sati Road, Tehsil Sikar, District Sikar.
This land is located in Rajasthan.
In Rajasthan, at Sikar.
And this probate is granted
in Dimapur.
Just for interruption, on a fixed place of abode, as per the act, it can be filed.
That's
So
it.
she had a fixed place of abode in Nagaland.
But in what manner? I'll show you. This is the first property. This is the property as I am referring, in respect to which the will was executed in my favor in 2012.
Yes, followed.
2 residential plots of land measuring 13,860 square feet situated at Sethi Colony near Bara Talab, Savli Road, Sikar, with residential building named Adinath Vihar, Rajasthan, with particular as stated in the will. This is the second property, which was given to me under the will of 2010. Now I make a point over here that this entire property during the lifetime of Kesri Devi Sethi was sold by registered sale deeds. It was not even left, but they were not knowing. The makers of the will, whenever someone makes the will, he has to know the facts. What are the facts? Whether the property still exists or not. When you make a will behind the executant of the bill, she is not knowing what you are getting signed. It is bound to happen that even the property is sold. You try to grab those properties.
When was it sold?
When she was from 2012 till 2018. And that I'll clarify from a suit which is on record before your lordship. Then these are the 2 immovable property at Rajasthan. The third Roman is plot of Vardhaman Nagar, zone number GV, Rajasthan, Jaipur, revised plot number so and so. There is no will in my favor in respect to this will property. And we don't even know whether this property exists or not over there. Then comes the fourth, movable property consisting of bank accounts, lockers, cash, shares as partner of Messer Dimapur Provision Store, GS Road, Dimapur, Nagaland, and income tax file. So these 4 properties were mentioned under the order. The properties at para number 6, 1 and 2 are situated with the territorial jurisdiction of the district Rajasthan, and the property at para number 6 is situated within the territorial jurisdiction of the district Jaipur, Rajasthan. At the time of death, the testator left behind the following legal heirs: Amarchand Sethi, Manju Devi, Pradeep Kumar, Pankaj Kumar, Ritu Sethi again, Miss Lavaya Sethi, Ditya Sethi, Master Harshvardhan Sethi. In view of the above facts as stated above, the petitioner has prayed for granting probate in respect of the will, the beneficiary being Srimati Manju Devi Sethi, wife of Shri Amarchand Sethi. Upon receiving the petition with above pleadings, this case was registered. Notices were published in the local newspaper and posted on the notices board of District Court Seeker, District Court Jaipur, District Collector Seeker, last residence of the testator, Deputy Commissioner's Office Dimapur, and District Court Dimapur. No objection has been received from any court. In the course of hearing, the petitioner has examined himself as PW and filed his deposition in affidavit supporting the pleadings in the petition and proved the probate petition as Exhibit 1. His signature in the petition as Exhibit P1.
So the other legal heirs did not contest the probate case.
These all are the legal heirs who are the sons of Manju Devi and daughters of Manju.
Who are you?
I am the beneficiary of a will of 2010 and 12 and a real
10 and 12, meaning thereby the other two.
The other two.
But those were, those are wills
of two properties.
Those are wills of 2010
and 2012.
10 and 12.
12.
And those have been willed to this lady by somebody else.
No. Those have been willed by Kesri Devi to the son of her brother.
1 second. Just a small
Yes,
confusion.
yes.
One second, Mr. Chaudhary.
We'll get your opportunity.
With the clarification.
At Annexure 6 and 7.
Yes, ma'am.
Will executed in favor of appellant by late Kesri Devi. Who had executed this will in favor of Kesri Devi?
No, Kesri Devi has executed the will in favor of appellant. Appellant is, before your lordship, is Narendra Kumar Jain.
Oh, by Kesri in favor of appellant. And these were done way back in 6/10/10 and 19/4/2012.
Well.
And finally.
And registered at.
And the appellant is Narendra Kumar Jain.
Appellant is Narendra Kumar Jain.
You are Narendra Kumar Jain.
Yes. Who is the beneficiary of the will?
These two properties have been executed, have been willed in favor of you.
Yes.
However, subsequently, by another will, these two properties has been executed in favor of Manju, the daughter-in-law.
Yes.
This is what you are trying to say.
Yes.
So that is the third will.
Yes, that is
there is no prohibition of a third will, but you are trying to say that the third will
if your third will is a valid will, I have a no case.
Valid.
If I have a no case.
If not valid. So you are basically challenging the validity.
And if the will is behind.
And your grounds for challenge is if I've understood you correctly, number one.
One is the known following the provisions of the Indian
Succession Act,
which requires that how a probate proceedings have to be initiated. What are the requirements? Secondly,
no, that is about probate proceedings.
Yes, probate proceedings.
But as regards the will, what is wrong with this will? Why are you saying it's not valid? The signature, are you saying if the signature is not?
Yes, signatures are forced. I am saying that.
Saying that.
And in respect to that, a FIR is pending.
Okay.
A suit is pending in regard to declaration of this very will.
I'm just trying to get a grip of your argument.
That's right.
Number one, you're saying signature is forged.
False.
Second, you're saying she was not sane.
Registered.
No, you're saying she was not sane at the time of.
Yes.
Right, you just said that.
Yes.
And third?
Third is that the probate proceedings, by not issuing a special citation to me that I am the interested person in this property, she knowing well, proceeded with the probate proceeding ex parte and obtained the probate. Without bringing in the knowledge of the probate court, that a stay order is there.
The first two will bear in front of the probate court.
No, because in Rajasthan, your lordship may kindly appreciate, in Rajasthan there is no requirement of probate. The will is itself
Will
sufficient.
is sufficient.
Will is sufficient.
So now the third probate case was here, right?
The probate proceeding
Yes.
initiated.
So
here.
that's why I'm asking, before this probate court here, whether those two wills have been,
No, they have not produced it.
they have
Nothing.
not produced.
Nothing.
So everything was behind your back.
Everything was behind.
Was behind your back.
And even in spite of a pendency of a suit at state of Rajasthan, seeker stay operating prior to this probate order without bringing that fact in the knowledge of the court, the probate was opting.
All right.
So at this moment before your lordship, I can say that probate proceedings were itself illegal. The question and validity of the will would only come if either she come to the seeker to prove his will, or if I am permitted to go in the probate proceedings, then only the question would come. At this stage, I am confining my argument before your lordship that how the probate is opting. And if the probate goes, my lords, then the declaration of this will to be null and void is pending at seeker, where there is an order of stay operating that in respect to these properties, records of rights and site should be maintained, and not bringing these orders in the knowledge of the court. And I'll show from the order sheets that how the probate proceedings have been initiated. So to start with, your lordship have the grips of the matter. Now your lordship may kindly see Indian succession.
I shall just take 5 minutes break
Break,
and then
break,
we shall
break,
resume.
break.
You can grab, both of you can grab yourselves a cup of coffee in the meantime.
Very good.
Some list of dates.
No, list of dates not from there. In the remove file. No, I know. Earlier we had filed some written
Written
submission.
submission, now the date is not
Yes.
matching with the written submission, that's why.
But I am from basically from basically I usually come to Delhi in active. Popular kind of market is. I electricity, but when petroleum matters in there. PNG lines. I have ONGC. And for state of Pakistan, all the electricity companies standing on it. Okay. Contested cases. It's very, there are few seniors. They don't come to Supreme Court because they're very so heavy. We have got very good senior Basava Prabhupada. Basava Prabhupada. He goes to Abdul times. That time he raised his after. As I see 3-4 years would be after years of being.
Yes, you are referring to the Indian Succession Act
Yes.
provision
Your Lordship may take up section 279.
279.
Yes. Because first I am dealing the issue that the probate proceedings right from the beginning suffers from defects and it was not in consonance with the provisions of the Act.
Okay. Yes.
Addition to statement in petition, etc. for probate or letter of administration in certain cases. Have you noted for it?
Yes, yes.
Every person applying to any court, the courts mentioned in the provision to section 273 for probate of a will or letter of administration of an estate intended to have effect throughout India shall state in his, I think so it's petition, but there in my book it's written position, ought to be petition. In addition to matters respectively required by section 276 and 278, that to the best of his belief, no application has been made to any other court for a probate of the same will or for letter of admission. There is a mandatory provision under this act that in every probate proceeding, a person filing the petition had to mandatorily disclose that in respect to this present will, no probate proceedings have been initiated.
So this has been done or not done?
Not. I'll show from the petition.
No, but, in the sense there can be two situations. One, that it is done but not mentioned. So here, what is the situation? Not done.
Your Lordship will find the petition. I'll take your Lordship.
One second, Mr. Gupta.
Admittedly, there was no probate petition pending also.
No, but that is a different thing.
It has been left out in the petition.
It has been
left.
It's not there in the petition. Not. Now kindly come to provision of 280.
280?
280 of the same
Yes.
Act. The petition for probate or letter of administration shall all cases be subscribed by the petitioner and his pleader, if any, and shall be verified by the petitioner in the following manner. The manner is also provided.
So verification is not done in terms of
Not-
280. You show me later on.
Yes, I'll show because that petition is there on.
Yes.
Now come to my lord's next section 281. Verification of probate by one witness. to
That
a
is also not done.
Not done. Though both witnesses are procurable. If they would, both witnesses were available.
But it was not
It was not done. They subsequently had placed their affidavits.
that they were there.
They were. So
But they did
can't
not
say
sign.
Not signed the probate. So 281 compliance is not there, where they have shown that how it has to be complied with ICD, one of the witness.
Which one? Which one?
The 281 I am reading. The form of the verification that attesting witness has to verify and what he has to write. I, one of the witness to the last will and testament of the testator mentioned in the above petition, declare that I was present and saw the said testator affix his signature or mark thereto, or that the said testator acknowledge the writing annexed to the above petition to be his last will and testament in my presence. So this is not done. I'll show from the petition.
All right.
Now come to clause 283.
Yes.
Subclause 3, I am referring subclause 3. Issued citations calling upon all persons claiming to have interest in the estate of the deceased. So this citation was never, this is not a general citation, it's a specific citation. General citation is by way of paper public publication. But if you know that any person is having interest in this property, then you will have to ask the court to issue a citation to him so that he can come forward and challenge the proceedings of probate and say that the will is forged or will is fraudulent or I am having interest on XYZ reasons the probate cannot be granted. So citation is mandatory for every interested person, which is not done in my case. Now your lordship may kindly come to the petition.
Yes.
It is at annexure.
What? Sorry, which section? The petition.
The petition.
So from the Indian Succession Act, you are referring to 279, 280, 281 and 283.
280.
Yes.
Now kindly see the petition whether it contains these facts or not. The probate petition, your lordship will find at annexure 2, page 27.
Yes.
The petitioner before this honorable court is bona fide citizen of India.
You don't have to read the whole.
So your lordship, if your lordship will go at the bottom, there is no verification. At page 31, the petition ends.
And there is no averment as regards
No petition is pending in any other court or not filed at anywhere at any other court.
That is not.
That is not.
All right.
The attesting witness is not there.
Okay.
Your lordship may note down that the two of the both attesting witnesses, they have subsequently filed affidavits. I'll come to those affidavits.
You will have to give me a gist of your argument.
Yes, yes, I'll give.
Yes.
Now, if your lordship will see, come to the page number annexure 4, will. Kindly see the will.
Page.
My lord, this your lordship will find at page 42.
Yes.
Kindly see the will, my lords. This is the last will and testament of Shrimati Kesari Devi Sethi, aged about 82 years, wife of late Bhajan Lal. Now kindly mark the age 82 years. And I can show that she was of more than 89 years on the so-called date of 2019 from their document itself. For that, my lords, may kindly come to that cancellation document which they got registered fraudulently. Kindly see that cancellation document.
Page.
Annexure 8, page 74. Kindly see like in what manner these documents have been taken. 74.
80 years.
When they are showing 80 years, kindly see this document has been said to be executed in 2012.
Where is the date?
My lord, your lordship will find the date only on the registration RD 37812 dated 1/10/2012. Why am these showing?
And the will is of
2019.
So then it would be more than 82. If we go
And I can show that both these documents have been created after her death on the same date.
No, this declaration is 29 June 12th. The date is there.
Yes, 29 June declaration is there, but registered on 10/10/2012. And the date has been shown as 80 years. So if we go by this.
Why I'm saying that? Because you see, the day 80 years is as on 29 June 12th.
Right.
Anyway, it doesn't change anything.
It will be after 7 years because the difference between the execution of the will and this declaration is 7 years. So she can't be less than 89. Now kindly see the wordings, my lords, of this. Para 2.
This declaration, she says this will be the fresh will.
No, this is not the fresh will. What I'm submitting, what is the declaration? Because whenever any person prepares a document, sometimes
as per this declaration.
Yes, she has executed a fresh will.
Correct.
And that fresh will has come into picture in 2019.
And this is after those two wills. These are the wills, right?
These are the wills she says that I am cancelling. That I hereby make this declaration, para 3, that I have made a fresh will. Because when you are making simultaneously the two documents, you are not knowing that what date document you have to prepare. You say, I am giving the fresh will. That means the fresh will has already been executed prior to this declaration. That I hereby make this declaration that I have made a fresh will.
Made a fresh will. So a will is already in existence.
Or to have been existent, this declaration is to be correct. But the will comes into existence of 2019.
Right. All right.
And if your lordship will read the para, what she says, I am the lawful owner of the property below mentioned, and the will of which I made on itne hereby revoke. Now, since my health is fine and I intend to use the property for my own use, as I am the true legal owner of the same, therefore I cancel all the former wills and codicils. Now, your lordship is well aware that will does not create a right. Till her death or till his death, a person is a lawful owner. He can do anything with the properties. Will always come into operation after the death.
That's all right.
So, if you and kindly see the signatures, my lords. They have endorsed the signatures of Kesari Devi.
Yes.
And kindly see the witnesses to these documents. This document.
Yes.
They are same as the witnesses of the document of 2019.
Okay.
Well, it can't be a coincidence that a document executed in 2012 will have a same witness in a document executed.
That is okay.
Maybe a coincidence. But that creates a suspicion in the mind of the court.
That alone, of course.
Alone, I am coming on other things. That cannot be alone, but this is one of the ground. What I'm raising.
The fact that this is of 12.
12.
And, now it could be that at that time there was another will. Later on.
They have not come out with that.
So I'm saying
yes,
that situation
yes.
also, because you see a person living can make as many as will.
Yes.
He or she desires.
Then she will have to cancel in the 2019 will. If suppose
the word cancellation
or she would have to disclose
the subsequent will.
The last will is the
take care.
Last will is the take care.
Correct me if I'm wrong.
Last will.
So there is no requirement in law.
There is no requirement. But your lordship will see.
I can understand that you are drawing the attention of these things because combined effect. And what is the?
I am trying to show before your lordship that this annexure 8 and the impugned will at the age of 89, without her knowledge, had been executed. She was not even senses, she did not even know this language.
What is there to show all that?
Manoj, I'm coming to that.
You have to show something.
Yes, kindly see both the earlier wills which were executed. They are in Hindi. Her signatures are
What
in
is
Hindi.
the date given there? Her age
80
in 12.
in 12.
There and here 82.
Here 82.
Where are those two wills?
Two wills your lordship will find at annexure. Six and 7.
Page 60.
6,
60.
60.
60.
Yes.
This is the will.
A translation copy is not there.
There, it's there, my lords. It's at page 63.
Yes.
I, Srimati Kesri Devi.
80 years.
80 years.
All right. The other one?
And this is the property which has been sold out. Entire property.
You have those documents.
I'll show from the plan. Now your lordship may kindly come to annexure 7.
66.
Page 66.
Translated.
Translated, your lordship will find at page 70. Again, the age is 80. So at that point of time, 10 and 12, she was 80, 82.
How can she be?
That's right, my lord. There is some gap of the age over here, but that gap is not so big that in
How? You are trying to.
I'll just intervene for a second. There is an Aadhaar card. The date is mentioned in the.
Right,
I'll
Mr.
come to
Chaudhary,
that
but,
Aadhaar card also.
Mr. Chaudhary,
I'll come to that
get
Aadhaar
your
card.
chances.
Sorry for
This court
interrupting.
doesn't like this piecemeal
I'm sorry.
arguments.
No, as my lord was
All
confused
right,
with the age,
all
there's an
right.
Aadhaar
So
Noted.
your lordship can
Where
take
is
it.
the Aadhaar card?
But Aadhaar card there, please.
Yes, yes.
I'll come to the Aadhaar card.
No, because you see, your own, the will which is in your favor are of two
Two
different
dates.
years.
Two different years, but the age is same.
How can it be?
That's right. That's right. my lords.
Now, if that can be there, even in subsequent will, there could be something.
No.
How
I'm showing why.
you cannot
So-
be blowing hot and cold.
No.
Mr.
I'm not
Gupta.
blowing hot and cold.
Why I'm saying is because in your
Agreed.
in the will,
I'm aware.
which you is in your
I'm
support.
aware that at least in the year 2012, she was around 80 to 80 years.
We don't know because you see 12 and then in 9, two wills. Now one is
10 and 12.
How can in
No.
10 and 12?
Sir, kindly
be
see the
80
dates.
years?
Again, dates. There are two not major year difference. Your lordship may kindly see.
We will
the
go
dates.
by.
Eighty-three.
When at the time of the
At the time
final
of
will.
that, at the time of final will, it will be 82 only. That's
Now-
the
now-
actual
Now
age.
kindly see the medical documents where she was 1 month before just death.
So these are on record.
These are not on record.
No,
These
how
are at
will-
record. These
how
are at record of the civil court. Because when FIR was filed against
But they
him,
are not record of
that's
the.
not, that's why I'm not giving it to your lordship. I'll
Right.
show from the record itself that if Aadhaar card, your lordship may kindly see what documents they have prepared. 23, they are showing Kesri Devi as alive in the voter list and they are filing the voter list of 23.
Where?
Here before your lordship. That is there in their counter affidavit. They have placed on record to show that Kesri Devi was residing at Nagaland and she had a place at Nagaland. They have filed the voter list of 23 where Kesri Devi has been shown as alive and a voter. That I will come across when I come to their counter affidavit. Just now I am showing the brief that how the matter is proceeding.
But let's go one by one.
Yes.
You see, as far as the age is concerned, it appears that the age has been recorded in different point of year, and it seems even in the will which is in your support.
Yes.
It is there is some anomaly.
That is.
Now,
But
for some reason,
yes,
if we remove this and we take the government document,
right,
the Aadhaar card,
right,
then it appears that the age recorded in the final will is matching.
If that,
You see, only on the age. I am
Agreed,
not going
agreed,
on anything else.
Agreed. If it would be matching, then in their two documents, which is executed in 2012, which is a so-called declaration of my wills to be cancelled. Her date of recording in 19, if my learned friend says according to Aadhaar card.
You see, 12 in 2012, that
Yes,
declaration
yes.
is of those two wills.
But what the age of Kesari Devi is written?
The age is recorded everywhere. That is why I am saying we are, if for assuming we don't go by the age recorded at several point of the year at several places, we don't go by that when we just take the Aadhaar card, which is a government document.
Right.
Correct?
Right.
That's a government document.
That's right.
Now, if we go by that, the age is nothing wrong.
Here the
Now, you see,
dispute is
Mr.
not
Counsel,
about the
I
age.
don't think you will.
I'm not disputing that.
Correct.
What
Let's not go into this age so much because had those two wills correctly recorded the age, this code would not have been going into all this. Then this code would have certainly, in the minds of the court, a doubt would have arisen as regards the final will date. But it appears at different places, the date has been differently recorded, even though in the will which supports you.
That's right.
So I am not going into all that.
What broadly I am making my submission before your lordship in regard to age is only to the fact that my submission right from the beginning is that the document of 2012, which is a cancellation document and a death document, a will, they have been prepared simultaneously.
All right, let's see the cancellation document.
Can you see the cancellation document annexure?
74, that declaration?
Yes, page 74.
Yes.
Kindly see that. I, Srimati Kesari Devi Sethi, age 80 years, wife of late Bhajanlal Sethi, at residing ward number so and so, near Baratala, Chanavli Road.
On what basis you are saying this is not correct?
But on the basis of the fact, for two reasons. Kindly see the signatures on this and signatures on the will of 2019. Kindly see.
Let's see.
Completely different.
Let's see.
And court has.
Where is the signature here? Kesari Devi. Yes.
These are on the left hand side.
Yes, yes. Kesari Devi. Now let's see the will.
The will kindly be seen.
Page.
Will your lordship will find annexure 4.
Yes.
Page your lordship 42. Kindly
see. I obviously I'm not an expert, but if
if
I compare, I don't find there is anything.
There is, already the honorable court has considered this fact and found that signatures are different from the admitted document, and in an FIR question which they filed, the proceedings were not quashed, but order was passed that investigation may go on.
Where is that order?
That I placed on record. What I'm submitting just to trying to give the brief.
So, but there is an inquiry as regards the signature.
Yes.
What is the status of that inquiry?
That is pending. For FSL, they are not producing the original document because we are not.
1 second, Mr. Gupta.
I'm sorry, absolutely false statement is made by him.
Yes.
There is a final report submitted by the police station. I can give it to your lordship now.
What does
just
it say?
now? It says criminal case should be conducted against him because of selling a property out of a will. He said just now. He said that he has sold the property.
This is an order after
Chaudhary,
FR.
Mr. Chaudhary and
This
Mr.
is an order after FR.
This is a wrong statement made.
And Mr. Gupta, just a small query.
Yes, ma'am.
Don't unnecessarily raise your voices.
Sorry, I'm sorry, but this is a
Just
wrong statement
small
made before the
query.
judge.
Is there any finding of the expert that the two signatures matches or the two signatures does not match?
No finding till date.
The finding has not yet.
There is no
come.
finding as such. Because
But this order to examine the signature was passed in a criminal court.
My lord, what happened? Police has examined, police has investigated the entire proceeding. In fact, Rajasthan police station has investigated and they have taken the statement of the deputy commissioner, registration officer. Everyone's statement has been recorded and they thoroughly found out that this registration had been done properly because it is not a normal will executed.
Where are those?
That document is.
This is the.
No, there is a final report submitted by the.
And what is this document?
This is a document after the final report. Police court has said that it is not in
Hindi. Where is the translated?
Because my lord, these are not part of the record. Neither is that I can place. That I can place. But just showing that I am not making an incorrect statement. The correct investigation.
Then he should have said that final report has been filed. Thereafter, there's a final report.
And this order is after the final.
After that,
the final report.
But my lord, the law is.
All right.
Yes, my lord.
Mr. Gupta, you please have this translated.
Yes,
I'm posting
I'll
this
get it
on
translated.
another date. I shall resume hearing only after translated
My lord,
version is
may I
there?
submit?
Because I need to understand everything.
Yes, that's what I'm submitting. I'll get it translated. For few minutes, your lordship may give me for few minutes so that things could be clear before.
No, and let's not unnecessarily invest more time. You have a translated copy if you want to rely this. This
No,
Hindi
your lordship,
language, this court will not understand.
For the time being, if your lordship will keep on.
When do you want it? By when can you have it?
My lords, I can have it by tomorrow. But difficulties,
No,
your
tomorrow
lordship
will
may
be
kindly
difficult.
appreciate the difficulty. Earlier also occasion, we are from Rajasthan. We have come
Counsel,
twice.
it is you who is placing this document. The document is not in the language this court
That's right.
would want it.
I go down to my
So,
lordship's objection.
therefore, have it in the language.
My lords, what I am submitting before your lordship, if your lordship will leave it this document,
You see, you are arguing a point. That point is a vital point about the signatures. It is you who is raising it. If this court has to go into it and you have said that a court has already passed an order, how can this court
there.
Yes, but it is in Hindi.
No, in English. Order.
Where?
That's what I'm submitting. Kindly
Where?
see the 482 order. That's before your lordship. Kindly see.
Where?
Yes,
Page.
your lordship. Just a minute. NHF 5. Page 54. Because what is happening, my lords? Subsequently, many things have happened in the suit as well as in the criminal procedure.
Page
54, my lords.
Now, which is this order?
This is an order passed in a 482 petition.
And what is this order?
This is an order of a criminal court. See what happens. The police files an FR. The FR has to be taken into consideration before the criminal court. Either the court can accept the FR or can refuse the FR. Before the finalization of the FR, they went to the High Court.
I have understood. Oh, before finalization.
Yes. And they
then-
say FIR should be quashed. Court said
And
no,
then-
FIR will not be quashed.
And thereafter, this is the order passed.
Yes.
Correct?
Yes.
What does this order do?
This order says that police authorities have wrongly filed the FR.
You please have this. This has an important bearing.
You only for a moment.
Sorry, Mr. Gupta.
I go down to my lordship's observation. If your lordship may kindly come.
Heard Mr. R. Gupta?
Bipin Gupta. B for
B. Gupta, learned counsel for the petitioner. Stop. Also heard Mr. K. Chaudhary, learned counsel for the respondent. Stop. In the course of the arguments rendered by the petitioner, Mr. B. Gupta relied upon an order passed by. I cannot read from here. Pass by.
I can pass it.
So you just say pass by?
If your lordship.
Passed by.
Court's name in exactly.
Passed by.
This is an order passed by Chief Judicial Magistrate Sikar.
Yes, Chief Judicial Magistrate Sikar, Rajasthan.
Rajasthan. Dated 25/5/2022.
Slow. Dated
25/5.
2022, whereby the final closure report submitted by the investigating officer in the criminal case
FIR number
pertaining to FIR number
61 of 2021
of 21.
This is the FIR
61 of 21.
Yes, 61
of 21.
Registered at police station.
Was directed what?
It was directed that वसीयत कूटरचित होने का कथन किया the अन्वेषण अधिकारी, that is the investigation officer, केसरी देवी के द्वारा वसीयत दिनांक 23/10/19 निष्पादित किए जाने अथवा श्रीमती केसरी देवी के हस्ताक्षर गलत रूप से बनाए जाने के संबंध में पर्याप्त अन्वेषण नहीं किया, which means that no investigation has been carried out by the investigation officer in regard to the signatures, whether they have been signed by the Kesari Devi or not the Kesari Devi. No investigation has been made by the investigation officer. Therefore, ऐसी स्थिति में in such circumstances प्रार्थना पत्र अंतर्गत धारा 173(8) स्वीकार किया जाकर the application under 173(8) is allowed. अंतिम प्रतिवेदन को आगामी अन्वेषण हेतु for further investigation
directed for that means the FR was not accepted.
FR was not accepted.
Whereby the final closure report was not accepted and further direction for investigation was directed. Stop. However, the aforesaid order being in Hindi language, the learned counsel for the petitioner is directed to submit a translated copy of the same in English before the court for assistance. Stop. List this matter again on
As your lordship. Yes.
My lords. Next week, my lord will be there to. If it is possible.
Any date, because doesn't make a difference.
But that's right, but I was hoping today that my lords will.
You see, Mr. Gupta,
That's right, that
you are relying on something which has
Yes,
some
yes.
bearing.
But that has
I
erupted
will,
for the
they
reason.
can, in the meantime, I just wanted to say, they can also file the final report or I will file the final report, which police had filed.
But there is already an order. You have not challenged that
Yes,
order.
the challenge,
That order is saying that final report.
let it be
will
on
not
record. I will also file a
is not
document.
accepted. You file.
I'll file it.
Stop. Mr. K. Chaudhary further seeks accommodation to file to bring on record the final closure report. Stop. Prayer is allowed. List this matter after 1 week on a date to be fixed by the registry.
My lord, better.
All right.
Then
Next.
maybe 2 weeks. 2 weeks.
2
because
weeks.
I was hoping if my lords would have.
2 weeks. Yes. Next.
For hearing, item number 26.
My lords, a fixed date may kindly be given because.
Liban, give a date after 2 weeks. All right. We
That
will
would
give
be
it. Court
convenient.
master will give it
Yes,
to you.
After the.
You consult both of
Yes,
you are
yes,
since coming
yes.
from outstation.
Yes.
Give a convenient date to the court master.
Right.
Highly obliged, ma'am.
Date to
Great.
date.
Very great.
Yes.
Great.
May it please your lordship. Your lordship, may I take your lordship to page 29, annexure 1.
Your counterpart is there, Mr. Joshua.
Yes, my lord.
Yes.
This is the,
Pay parity.
yes, your lordship.
This is the Dobashish case.
Yes, my lord. The Dobashish case. We're asking for pay parity in the lowest
same
pay scale in the latest ROP.
Hearing on the last occasion.
Yes, my lord, day before yesterday.
Yes. What was because I think to an extent this court was
My lord.
could have heard you, right?
Yes,
To
my
some
lord.
extent.
Yes, your lordship.
Why the matter was fixed today?
Your lordship, because on that day when the matter was being heard, partway, my learned colleague for the state, he had an urgent work that cropped up and he had to go away from the
All
court.
right.
My
Now,
lord, here, the
yes.
petitioners are paid 1993 ROP. My lord, after the 1993 ROP, my lord, may,
Submitted one decision, right?
yes, your
Jagmeet
lordship,
Singh.
the Jagjit Singh, state of Punjab versus Jagjit Singh.
According to you, principle of equal pay for equal work,
My lord,
isn't it?
yes, your lordship,
Here, just the relevant things you show,
my lord.
because no need of reiterating
Yes, my lord.
the entire submission.
Then
Because
may I
if
take
I
your lordship?
remember,
My
you almost finished.
Yes, your lordship. Then may I take your lordship to my prayer?
Yes.
Because of the prayer, I need to.
Yes, please.
Yes, your lordship. It's a page 27
Page
of my writ
27.
petition. Yes, your lordship. Number 1 is already covered, my lord. Prayer A, page 27, 27.
Yes.
Direct the state respondents to pay the petitioners the equal pay for equal work as per the latest ROP rules. That is ROP rules of 2017, my lord. Now, B is the concern which I'd like to raise before your lordship for your lordship's
Page
consideration.
27. Page, sorry,
27.
I have, by mistake, I took out annexure 27.
Oh, my lord, page 27.
Page 27. Yes. page
Prayer
27.
B requires an extra consideration of this Honorable Court, my lord. This is direct the state respondents to pay the petitioners the correct entitlement under the irrelevant ROP rules with effect from the date.
Things you are seeking, one, equal pay for equal
Yes,
work,
your lordship.
and the entitlement under the correct ROP. Correct?
Yes, your
The
lordship.
entitlement under the correct ROP rules.
My lord. So from the date they were granted scale of pay with consequential benefits of areas thereof.
Equal pay, equal work, you have to show
Yes,
that,
my lord.
and you are a temporary worker.
Yes, your lordship.
So regular Dobashis are getting a
The-
particular pay.
Yes, your lordship.
You are not given that same pay.
My lord.
Is that your case?
Yes, my lord. So if my lord may kindly
And
take
what
note.
is the stand of the state government?
The state government is taking the stand that according to the rules, the committee is empowered to fix the pay of the employees. Now, the rule that the state in their affidavit, which my colleague will be showing your lordship, The stand is that, as per the rules, the committee has the authority to fix the pay. But the rule does not say on which ROP it should be fixed. It is just their interpretation. And as far as the law is concerned, my lord is fully aware and in grasp of the situation that the law is settled. So it has to be the latest ROP. And the committee is not empowered to act in a way that is arbitrary and against the settled
Where is
principle of
that,
law. My lord.
government in the affidavit?
The government's affidavit.
Yes.
Your lordship.
Affidavit filed by respondent number?
5, your lordship. The finance department.
You are appearing for 5?
Lordship, in fact, on the earlier occasion, I appear for respondent number 1 to 5, 1 to 4, Lordship. In the course of hearing, Lordship, since respondent number 5,
Was
being the
completed.
competent authority, has been impleted. And thereafter, amended petition was filed by the
So
petition.
are you appearing for R5?
Lordship, 1 to 5.
Yes. Which part?
So they are relying on section 6, my lord. Section 6.
No, paragraph from here you want to show? A5's affidavit, what do you want to show?
In the paragraph 5 of the affidavit for respondent number 5, my lord.
So I think paragraph 5, right?
My lord. May I read, my lord, the government's affidavit? That with regard to the statements made in paragraph 45 of the Writ petition, the answering deponent begs to state that work charge and casual employees up till ROP 1993 were eligible for scale pay. However, from the ROP rules 1999 onwards, the rules are applicable to regular employees only, wherein work charge employees are excluded from the rules. The wage of work charge and casual employees are regulated by the Nagaland Work Charge and Casual Employees Regulation Act 2001. From the Regulation Act, it clearly spells out that, more particularly Section 2, subclause C and D, that states that casual employees means employee engaged without sanction post, and work charge employee means an employee engaged without sanction post and the work charge establishment. Therefore, from the conjoined reading, the petitioners are appointed under the work charge and casual employees, which is governed by the Regulation Act of 2001.
Distinction is being sought to made between the casual employee and between the regular employee and the casual
Yes, your
employee,
lordship.
right? According to them, till 93, they were eligible under the
Your lordship.
ROP.
My
But thereafter, the casual employees will be regulated by the Nagaland Work Charge and Casual Employee Regulation Act.
Yes,
So
your
the
lordship.
pay will be as per that.
Yes, your
This is
lordship.
the stand of the state.
That is
correct?
that is what they are.
But
talking
you
about.
are saying that since you are discharging the same work,
Yes, my lord.
therefore you should be given the same pay.
Yes, your
This
lordship.
is your content.
Same post, same
Now,
job.
this
Yes, your lordship.
decision of the apex court in Jagjit Singh is between regular and casual employee.
Yes, your lordship.
Is it
In fact, it covers even the daily laborers also, your lordship.
temporary employee?
Yes, your lordship. May I read further, your
Yes,
lordship, the
please.
second
Yes,
part?
please.
In addition to that, the Regulation Act of 2001, Section 6 states that the work charge employees shall be paid wage as may be prescribed by the state government on the consideration of the recommendation of the Work Charge and Casual Employees Commission. So this is where they are trying to divert to say that the commission, the Casual Employees Commission, has the authority to fix the pay according to their own likeness, your lordship, or their understanding. Accordingly, work charged and casual employees drawing scale pay under ROP 1993 have been granted the benefit of revision of pay by PNR Department OM number so-and-so dated 17/3/2015. So this is their specific stand, your lordship. May I take your lordship to section 6 of the act, which is at page, your lordship, at page 13, my lord, 13. Section 6. Page 13,
Yes.
13. Section 6, wage. The work charged employees shall be paid wage as may be prescribed by the state government on the consideration of the recommendation of the commission, provided that the wage of the work charged employee who was paid a scale of pay at the commencement of this act and who is reappointed under subsection 2 of section 5 of the act shall not be less than the last pay as may be determined at the time of prescribing fixed wage. So this particular section, or the section 2 which the state has quoted, in no way does it mention that the,
It should not follow the ROP.
yes, your lordship. So it's just their
Well,
interpretation, my
To
lord.
that extent, you are
Miller.
Mr.
Joshua.
Joshua.
Yes,
Mr.
your lordship.
Joshua is correct. Section 6
My lord.
merely says that the work charged employee shall be paid wage as may be prescribed by state governments, right? On the consideration of the recommendation of the commission. So commission will give a recommendation. On that basis, state government will fix the wage
Lodge.
of the work charged employee.
Lodge.
Correct?
Lodge.
Proviso says, provided that the wage of the work charge employee who was paid a scale of pay at the commencement of this act and who is reappointed under subsection 2 of section 5 of the act shall be not less than the last pay as may be determined at the time of prescribing fixed wage. Now, this doesn't say that you are prohibited or you are there is a bar for you to give the work charge the pay which the regular work charge discharging the same same work
Miller.
is getting. There's no bar,
Lordship. Lodge.
isn't it?
Lordship.
Because this decision of the Apex Code you have seen, the one which was cited, 2017, 1 SAC 148, do you have a copy? Have you seen it?
No, Lordship.
Please have a look, and because you have to reply to this decision, because as per this decision, it has to, the temporary employees are entitled to minimum regular pay scale on account of their performing same duties as discharged by regular employees against sanctioned post.
My lord.
Lordship, here is a case where the petitioner were appointed against non-sanctioned posts.
Correct.
Lordship. And there were, some of them were appointed on casual, some on contingency, and some on ex-cadre post, Lordship. So, Lordship, as far as the Work Charge and Casual, Nagaland Work Charge and Casual Employees Act is concerned, Lordship. Lordship, here it has been clearly mentioned that page 7, Lordship. Page 7 and type copies at page 8. Definition. Definition is given
yes.
2C. It states that casual employee means an employee is engaged without sanction post. And thereafter D.
Work charge.
Work charge employee
Without
means
sanction
an employee is engaged without sanction post and the work charge.
These are engaged without sanction post.
Without sanction post.
Yes.
And thereafter, what happened, my lord, there is a series of notification issued by the state government.
But the question that this court is posing, is there a bar for giving them the same wages which the person appointed regularly to a sanction post is getting?
Lordship.
Is there a bar?
Lordship, if they are regular employee, Lordship, definitely they will be getting the ROP of latest ROP of 2017.
No, that is not the question. You see, you are getting their, it is you who have given them the temporary appointment, correct?
Lordship.
Correct. And there is no quarrel at the bar that he is performing the same duty as that of a regular employee, correct?
Lordship, that they have to explain, Lordship.
No, that is you. You are the state. You have appointed him temporarily. You have appointed, correct? So you know what is the job that the Vashish is performing. Now, in that situation, why the same pay cannot be given? There is no bar in your Nagaland work charge and casual employees regulation.
Lordship.
Have you followed the question of this court?
Lordship.
You haven't seen this decision, 2017, volume 1, SSC 148. You have a look at it.
Lordship.
I'll take it up on Monday.
Lordship.
You have a look at it. And in the meantime, you have already heard the court.
Lordship.
So you find out, get your instructions also on this.
Lordship.
Then this court can dispose of this case on Monday.
Lordship.
This is because the entire issue is that.
Lordship.
And Mr. Joshua, in the case of Jagjit Singh, this is relating to a sanction post.
No, your lordship. It is
Both.
for the, yes, casual as well as temporary,
No,
all
but to
covered.
post to a sanction post? Because you see, the head notes indicate against sanction post.
Yes, your lordship. So whether the temporary, casual or daily laborers are entitled to the basic pay scale of the regular employees? That's the
So
question.
that is one of the
Well,
question, but there is also a distinction when the sanction
Yes, Your Lordship.
post comes, right?
Yes, Your Lordship.
So you please examine Jagjit Singh case once
Yes, Your
again
Lordship.
and see whether those casual employees were appointed against sanction or non-sanction post.
Lordship.
Please find that out as well.
Lordship.
It's
Lordship,
there, Your
yeah.
Lordship, in the paragraphs that I have already put.
What is it? It is against a sanction post,
No.
non-sanction post.
Yes, Your Lordship.
In Jagjit Singh.
My lord.
You see, in that situation,
Lordship, in the head note, it says that on account of the performing same duties as discharged by regular employees against sanction posts. So let me.
Regular
It's charged by
employees are against
regular
sanction.
employees against sanction post. So you see, this case otherwise squarely covers the case. Before I can dispose it right now also, because I can see in line of this. But I'm only giving you an opportunity because you appear to have not gone through this decision. So have a look at it. If you can distinguish, we'll hear you. But I think this decision covers.
My lord.
And there is no bar also in your Nagaland regulation, the work charge. There is no bar. I was of the impression when you were arguing that perhaps there is some bar here.
There is no
There is no
but,
bar. It says the state government will fix.
Your Lordship, my learned colleague can also have a look at the 2019-12 SCC, page 297.
That citation is not given to the court.
Yes, Your Lordship, I am yet to give it to Your Lordship.
You give a copy to the court as well.
2019-12 SCC 297.
Please give it to him.
My lord.
You have a look. This is after Jagjit Singh.
Yes, Your Lordship.
And they have reiterated the principle of Jagjit Singh.
Lordship.
I'll have it tomorrow or Monday.
On Monday, Lordship. Monday. Let me
Many
go through
matters
that.
are being fixed on Monday. But please get it and no
Lordship.
further adjournment. I'm keeping
Lordship.
it part heard.
Your Lordship, we can try tomorrow also if my brother is.
On Monday, Lord.
All right. I'm keeping it part heard. So please, like a hard in part. Mr.
Vijmom.
V.
Vijmom.
You mean learned counsel for your additional?
No. Junior government.
Learned junior government advocate for the state. Seeks time to go through the citation cited by Mr. Joshua so-and-so, learned counsel for the petitioner. Stop. Prayer is allowed. List again on Monday so-and-so. Only to that extent. Okay?
Lordship, only to that.
Like this.
Lordship.
For admission, item number 5.
Yes.
My lord.
Yes.
My lord, I'll withdraw the matter, my lord, with the liberty to file afresh at the appropriate forum. My lord, might kindly make a short observation, like on the ground that like section 34 is not the High Court is not an appropriate forum under section 34.
Are you aware of the Assam High Court order 1948? You will find it in the Gauhati High Court rules at Appendix 1 at page 254. Have a look at it, and it is clearly mentioned. The High Court of Assam shall have, in respect of the territories for the time being included in the province of Assam, all such original, appellate, and other jurisdictions. So,
My lord.
original appellate is what is provided with the High Court.
My lord.
The
My lord.
original, otherwise, civil jurisdiction is with the district court. So, in that way, this is not maintainable. So, I don't think I need to say anything. If you want, I can give a detailed order. Otherwise, if you are withdrawing, I'm simply allowing it. It is not.
My lord, I can make a short observation. I need to satisfy my client also, my lord. My lord, that observation can be made, my lord.
You show this provision to your client. You show the provision. Heard, Mr. Your name?
Michael.
K.L. Michael.
Yes, my lord.
Learned counsel for the petitioner. Stop. Also heard, Mr. FP. MSO. Learned, please give your name. Learned additional.
Advocate General.
Advocate General. State. Stop. The fine. Where's the fine? This is an application under section 34 of the Indian Arbitration Act. Of the Arbitration and Conciliation Act 1996.
Yes, ma'am.
seeking setting aside of the arbitral award dated 29/2/2024, which was delivered stroke pronounced on 16/3/2024, passed by the arbitral tribunal. Stop. Section 34 of the Act provides recourse to a court against an provide recourse to the court having principal civil court of original jurisdiction in a district and including the High Court in exercise of its ordinary original civil jurisdiction against the arbitral award. Stop. In terms of the Assam High Court Order 1948, Order 4, the High Court, the Gauhati, the High Court of the Gauhati High Court does not have original jurisdiction, does not have the original civil jurisdiction and therefore the present application is not maintainable. Mr. So-and-so, learned counsel appearing on behalf of the petitioner submits that he may be allowed to withdraw the application in order to enable him to file the same before the appropriate forum. Prayer allowed. Petition stands dismissed on withdrawal.
I'm deeply obliged, madam. So obliged.
There is an IA. IA stands disposed of accordingly. Huh? All right.
Obliged.
Lima, put the disposal against both petitioner and both. Yes. Done.